just going to play a clip of Angela Rayner and Jonathan Reynolds talking about the employment law that Labour is putting forward.
Our employment rights bill is on the way. This will be the biggest upgrade for workers' rights in a generation.
The best businesses know that people will do their best work when they're happy at work, and this bill provides for security, for respect for everyone. It removes unfair practices.
Banning things like exploitative zero-hour contracts, ending fire and rehire, and giving people that security that they need and deserve.
This has been spoken about on the media a lot, about how it's going to make work pay. That's the heading that they're going for. What's your take on the actual legislation? Is that the case?
Yeah, well, they're definitely right to say that this is the biggest upgrade for workers' rights in a generation, but that doesn't really say very much, does it? Because we haven't had much change to the law on work in the last 20 years, if that's what you count a generation. The government has to be congratulated for doing something about the state of labour law, industrial relations law, and so on. But the problem is that workers, of course, will be grateful to have extra rights and so on, but it doesn't really go to the real heart of the problem. And the heart of the problem is the imbalance of power between worker and employer. And the only way that you can redress that and give workers a real say over their pay, over their terms, their conditions, over giving them voice at work, the only way it can be done is by strengthening trade unions. And what people tend to overlook is that whatever it was, 45 years ago when Thatcher came to power, the Tories passed 6 acts of parliament which imposed such limitations on trade unions that they now find it very, very difficult legally to defend their members and the working class generally. And what is needed in this legislation is freeing up the unions from those restrictions. Of course, there are some restrictions which will be removed. They're going to get rid of the strikes minimum service level Act. They're going to remove many of the restrictions imposed by the Trade Union Act 2016, but they're not really attacking the restrictions which were imposed all those years ago in the 1980s and the 1990s. And those restrictions, and it's not just a matter of a sectional interest for trade unions doing them a favor. It's required by our obligations under international law. Britain is a country which is meant to abide by the rule of law, and that means international law as well. It means conforming to the obligations in international treaties which the United Kingdom has voluntarily ratified and by which it ought to be bound. And the truth of it is that the international bodies, the International Labour Organization, the European Social Charter, and so on, reviews every country in respect of its in respect of the obligations that it's undertaken. And on every single occasion since 1989, the United Kingdom has been found to be in breach of its international obligations in relation to the law on industrial action and other laws as well. Now, one of the things that the Labour Party agreed to in 2021 when it adopted a document called A New Deal for Working People, one of the things in that was that the new law would bring in our industrial action law into conformity with our international obligations. And that commitment appears to have been dropped from the Employment Rights Bill, which I think is an awful shame. And I don't know how many generations is going to take to put that right. But mind you, everything is not lost. The government says that it's going to consult further, so it'll really be up to the trade unions to press the government to go further. Now, of course, I'm only selecting certain aspects of industrial relations law. There's an awful lot in this bill yet to come, and there's an awful lot of items that were in a new deal for working people which are still open for discussion. But the problem is that over the last 45 years, the balance has swung so far in favor of employers, particularly bad employers, and against workers, that the real need now is to redress that balance and bring workers back, to give them voice through their unions into setting pay terms, conditions, and so on. And the bill at the moment, and as I say, there's a lot of consultation still to come over the next 2 years. But at the moment, in my view, the bill simply doesn't go far enough. For example, over the last few days, we've had a lot of discussion about Lou Haig, the Secretary of State for Transport's comment about P&O, the P&O Ferries case. And you recall that what happened in that case was that P&O sacked all the seafarers on the ferries across the channel, the P&O ferries that go to and fro across the channel, sacked, I think, 796 seafarers, mostly British. They were sacked by text message. They were given 15 minutes to get off the ships. And on the quay side, they found buses full of agency workers who'd been recruited from the Far East and elsewhere at wages which were just a fraction of the wages that the British seafarers had, and just a fraction of the national minimum wage even. And what happened then was that the unions were unable to take any action because, of course, their members were unemployed. They were prevented by the law for calling on solidarity action by dockers or the people that refuel the ships or drive lorries onto them and so on, because all forms of secondary action are prohibited in Britain. They were powerless. But what we found out, because the managing director gave evidence in the House of Commons, what we found out was that the employer had worked out the maximum compensation for breaking the law and gone ahead and decided to break the law, pay the compensation, because they could make up the profits, but by using the cheaper crews. Now, in the debate that's been in the media about what happened then, I've seen no mention of the fact that the employer, ultimately owned by DP World, had not just sacked the entire British crews and replaced them by cheap foreign labour, but they'd done so willfully, breaking the law and deciding knowingly that they were going to do that because it was more profitable to break the law than it was to conform with the law. And the proposals which we've heard about in the Employment Rights Bill simply would not prevent that situation happening again. And I think that's a terrible thing. I mean, it's a very good litmus test, isn't it, for whether the Employment Rights Bill is doing what it says on the tin. Would it prevent P&O Ferries sacking the entire crew again and replacing them in breach of the law? No, it would not. So there's a lot to be done to strengthen this bill. I wanted to say just two other things, if I may, Crispin. One is about the day one rights. Basic rights are to flow from day one. That is a very, very welcome step. But one of the rights, which is to every worker should have from day one, is the right not to be unfairly dismissed, or rather the right to take a case to a tribunal if he or she is unfairly dismissed. Now, there's a lot of talk about probation periods, suggested probation period for everybody in the country of 6 months. But what we don't know yet, because it's not in the bill, is what the effect of a probation period would have on somebody claiming unfair dismissal in the first week of work. And what we envisage, of course, is somebody who's sacked for totally unreasonable, irrational, arbitrary reason, nothing to do with their competence or whether they can do the job or something like that. Can they take a case to a tribunal even though they're on probation? I can't see any reason why they shouldn't be able to do that. So we need a bit of clarity on what probation will mean. And the other thing I wanted to mention was 0 hours contracts. There are provisions in the bill right at the beginning on 0 hours contract. Now, I challenge any one of your viewers today to have a look at the bill, which you can see online. Just put Employment Rights Bill, stick it in Google and have a look at it. You read the first 10 pages of that and tell me if you can understand exactly what the workers' rights are in respect of 0 hours contracts. It's the most complicated piece of legislative drafting I think I've ever seen. Now, of course, lawyers are used to that sort of thing. No doubt they'll deal with it in due course. And I also accept that dealing with 0 hours contracts is a difficult legal issue. But workers have to understand what their entitlements are. I mean, if rights are to mean anything, they've got to know what their rights are in relation to 0 hours contracts and so on. And that is one of the problems with individual rights, that it's left to the individual worker to assert his or her rights and take a case to a tribunal. And there's a lot of problems with taking individual cases to employment tribunals. For one, as Ian mentioned, the period to bring a claim is only 3 months, but the delay in tribunals is now many, many months, sometimes years, before you can get a case on for hearing. And we know from the recent statistics that the rate of success in employment tribunals is very low. And if the worker is successful and gets an award of compensation, that compensation is limited by statute to a maximum, and 1/3 of the awards made by employment tribunals are never in fact paid by the employers. Now, there are measures in the bill which hopefully will allow the Secretary of State to take action against the employers that don't pay the compensation. But these are the kinds of problems that there are with individual rights, which is the reason why it's so important that trade unions are strengthened, so that people's protection is through collective agreements at work, both at enterprise level and a sectoral level across the industry, so that unions can negotiate what workers are entitled to and resolve by discussion any problems that do arise, any complaints of unfairness in any respect at all. That's what we need. The legal solution is good for lawyers, but it's not necessarily good for workers.